The answer to your question is yes. The primary impetus in collecting your judgment is upon you and your attorney. The court will give some types of assistance, some automatic and some discretionary. Now, when I say automatic, it's not entirely automatic. Some, more properly, it's some assistance you are entitled to as a matter of right. If you prepare and file the right paperwork and jump through the hoops, it'll automatically be granted. For example, something like a writ of garnishment or a writ of execution. If you apply for it post-judgment and you pay the small filing fees involved, the court will, without question, just issue these to you. If you want to take a post-judgment deposition of a debtor or anyone else who may have information about a debtor's assets, you must file a motion with the court to do that in most jurisdictions. And the court generally, without question, grants that without any questions being asked of you or of your lawyer. Now, there are other post-judgment remedies available to you and your lawyer. There's a whole panoply of them, a whole range or spectrum. A debtor is always exposed to any of those being deployed against the debtor and the debtor's asset structure. A creditor who has these remedies available has them on a cumulative basis, and there's no in general, there is no or very little regulation on the order in which you choose to use them or deploy them. But some of them are discretionary with the court. Some types of relief that a court may give a creditor will depend on the facts and circumstances of your case. For example, if I want orders that are going to be binding upon and affect third persons who are not a defendant, but who are closely affiliated and associated with the debtor, brother, sister, business confidant, fellow fraudster, I have to make special showings and in essence must persuade the court that this is a circumstance that the court ought to use its discretion in granting extraordinary post-judgment relief. This is always a fun area, an exciting area, and an area that often tends, when granted, to exert tremendous pressure upon a debtor. And a debtor will come to the table to settle generally when their pain threshold has been exceeded by the quality and timbre of the post-judgment orders being exerted against them.